let me start off by thanking the library for inviting us to participate. I think there's a lot of people in Marin County that might not know what Legal Aid of Marin does, but we help low-income people around Marin County on a variety of issues, including housing issues. We have a housing team. We deal with senior issues and financial elder abuse. That's also under my purview. I'm actually one of the supervising attorneys at Legal Aid, besides being the senior employment person. The employment team, what we do specifically, and you can go on to the next slide, is we specifically help, and it's changed quite a bit this past year, but we primarily help with what we call wage theft cases, wage and hour violations, failure to pay overtime, you know, people not getting their lunch breaks, which I'm going to talk about in some detail in a few minutes. You can see this lovely picture of my team here, Henry and Adriana. And we go out into the community, primarily in the Canal, Marin City, and other underserved communities in Marin County, and work directly with the community. As I was explaining to Shireen before we got started tonight, we've been out there in the community all through the pandemic. Our office was closed to the public, but we continued to meet with workers individually, particularly those who didn't have access to getting unemployment benefits, didn't understand how to apply for them. You may have read all the articles about how overwhelmed the unemployment system was at the beginning of the pandemic. And, you know, a lot of the problems have straightened out. It took a long time to get there, but we finally got there. And so, and then throughout the pandemic, there were a lot of people who lost their jobs because they got COVID. There were businesses that closed down. A lot of people didn't pay final paychecks before they closed down. And so Legal Aid collected over $500,000 in back wages last year for over 140 different workers. So we do a lot of the wage and hour cases before the labor commissioner, as well as the unemployment cases with the EDD. Our team also handles discrimination cases. We're very select about them. Usually we'll take cases that we call impact litigation that have far-reaching significance. We do have some other litigation cases as well. And we also have a public benefits team, which helps people get general assistance, unemployment. We help people get Social Security disability income. So that's kind of an overview of what our particular team does. Next slide. Okay. And I think I've just mentioned all these, so you can go on to the next one. Okay. So these are some of the benefits that are out there for unemployment right now. I don't know if anybody on the call tonight is or has been unemployed, but a lot of people don't know that you qualify for unemployment unless you have no papers to be here legally in the country. Unfortunately, any undocumented workers cannot get unemployment, and that was very traumatic for a large portion of our community, particularly from the Canal. We're talking about people's housekeepers, caregivers, day laborers, people who worked in construction, all of whom were often paid in cash, some people working for years and years and years at a company, but they lost their job, and because they were paid in cash, there was a difficult time being able to apply for those benefits. But you are entitled to benefits if you are paid in cash and you do have documentation. On occasion, the person may try and deny that the person ever worked for them, but for the most part, we haven't seen people doing that, even if they paid in cash. That did create problems during the two avenues under the CARES Act for the stimulus, not the one-time stimulus payments, but the weekly additional benefits that were $600 a week, and then it went down to $300, and I think now it's back up to $400. But for people who did the gardening, the caregiving, the housekeeping, they're still considered employees, even if an employer decided to give them a 1099. Under California's legal definitions of what constitutes an employer and employee relationship, most of these would fall into the employee-employer relationship unless they really did have their own business and work for a lot of different people. A lot of the claims got denied because there was no record of the employment because people were paid in cash, and therefore we had to file a lot of appeals where we had to explain that. Some people had to undertake a different avenue to get those benefits, but overall in 2020, we won 90% of our unemployment appeals, and people did eventually get their benefits. The sad thing in both the wage theft cases and the unemployment cases is people have to wait a long time to get through the system to get paid. And we really saw a lot of people suffering, during especially the early months of the pandemic. Okay, next slide. Okay. So these are some of the benefits that have been and were available from retroactively to January of 2020, and then is now extended through September 30th, 2021. And part of the CARES Act includes the Families First Corona Response Act. And that does two really important things. First of all, for any business with more than 25 employees, and this is true under California law as well, a worker who gets COVID or has to stay home and be quarantined because someone in their family has COVID is entitled to up to 80 hours of paid sick leave at the employee's regular rate of pay. A surprising number of employers didn't know about this law. All throughout the year, we were constantly educating people who got sick, especially full-time workers, that a lot of employers said, well, I paid them for 3 days of sick leave, but in fact, they were required to pay 80. And it's in a few cases, unfortunately, we saw a lot of people die of COVID last year, and then we need to get that sick leave paid out to the surviving spouse. The other significant part of the CARES Act is the 2 weeks for employees who have to take care of their children. And I think we should go on to the next slide for that. No, I'm sorry, could you go back one? Okay. I can't see how far down it goes, but basically, if you inform your employer that you do have to stay home to take care of your children, this may become less relevant as they go back to school. But if you have children and if you are only able to do your job from home, they're supposed to accommodate that and also give you a kind of family leave that allows you to take care of your children's schooling at 2/3 your regular salary. There are a number of steps that you have to go through. We're happy to help people who need to get those kind of benefits. Or you can go to the Department of Labor website and get that information. Just type in Google Department of Labor, FFCRA, and you should get all the steps that you need to go through with your employer. And feel free to interrupt with chat questions anytime. You know, I want to be responsive to what you all want to hear about. Next slide. Okay. In addition, a covered employer under California law is that an employer must provide to employees that have been employed for at least 30 days up to an additional 10 weeks of paid expanded family and medical leave, again at 2/3 the employee's regular rate of pay. This is for that same child care requirement. Okay, next slide. Okay. Sorry, I'm still having a hard time getting everything on there. Okay. So the employee qualifies for all these things under these particular conditions. Again, you can get more information about that on the Department of Labor website if you need those benefits. Next. And again, these are what the benefits are. 2/3 regular rate of pay or the applicable minimum wage up to $200 per day and $2,000 over a 2-week period. And can you go to the next slide? Okay, and then I think the next one. No, sorry. Okay, here we go. So this is the bread and butter of what legal aid does. As I mentioned, there are a lot of employees in Marin County who do certain kind of work and they don't get paid the wages owed to them. A really typical thing that happens, and I'm constantly having this conversation with the employers, is someone will pick up somebody as a day laborer. They'll bring them to their house. They'll say, you know, I'm going to pay you $500 to paint these 5 rooms in my house. And then at the end of it, they say, well, I don't like the job you did. I'm not going to pay you. It doesn't work that way. I can't say to my secretary who does a bad job typing, you know, a letter for me, no, you need to go retype that letter. I know I'm old-fashioned using the word type anymore, but retype that letter. And I'm not going to pay you for the time you spent doing it before. The law says you have to be paid for each and every hour and minute worked. And that's whether you think somebody did a good job or a bad job. The remedy, if you think somebody did a bad job, is you fire them. That's the remedy. But the remedy is not paying the wages. Another thing we see is the failure to pay overtime for workers over 8 hours in a day. We have a big case right now going on against Cavallo Point Resort and Restaurant, where the kitchen workers, as well as other workers there, work essentially a 10-hour day, but they're required to clock out after 8 hours and continue working. So they not only don't get paid overtime, but they don't even get the minimum wage. So that's against the law. After 8 hours in a day, even if you are working less than a 40-hour work week, you must be paid time and a half. If you're working 12 hours or more or on a Sunday, you're required to be paid double time. Another important part of the wage and hour laws is in California, almost every category of worker, and this applies whether you're a salaried employee or an hourly employee, depending on how you're classified, you must be provided with a 10-minute rest period for every 4 hours worked. So in a normal 8-hour day, that's 2 10-minute rest periods. And you must provide a 30-minute uninterrupted meal period. If an employee doesn't get that, the employee is entitled to an extra hour's wage per day. These violations are very common in the restaurant industry. For example, people, start to eat their lunch, but they get interrupted because an order comes up, they take it to the table and they have to come back, or the restaurant's too busy for them to do it. Some of these restaurants will still require the employees to clock out for a 30-minute lunch break, even though they're not really getting that break. If somebody's a driver and they're eating in the car from one job to the next, and they have to do it that way or they won't get to the customer on time, that is also a missed meal period. It's not a question of whether you eat, but whether you have that half an hour of duty-free time. If you're eating and your boss is calling you or texting you during your lunch break, again, that's an interrupted meal period. So for the small employers out there, always try and make sure your employees do take their meal periods, and employee handbook should really make it known that meal periods are required. They cannot be waived. Now, the law also says that if you work more between 10 and 12 hours a day or over 12 hours, you're entitled to a second meal period. A lot of employees don't know that they're eligible for a second meal period. And so they have to specifically waive that right to a meal period. Can't waive a right if you don't know that it actually exists. And I've had a lot of cases that regard missing the second meal period of the day. I had many cases years ago in LA dealing with refinery workers who worked 7 days a week, 12 to 14 hours a day on what they called turnarounds. And this would go on for about 6 weeks, and people weren't given those second meal periods or paid for them. It's also important to know that your job, depending on what your salary is, if you make less than twice the minimum wage, so right now that would be less than $26 an hour, your employer must reimburse you for things like uniforms you're required to wear or get cleaned. If you have to use your cell phone for your job, they have to reimburse you for those expenses. They have to reimburse mileage, gas. If it's construction, they have to provide the tools for the job and cannot require that the worker purchases these tools or items by themselves.
We have a question in the chat that's relevant here, so I'd like to break in if I may. The question reads, if you are working for extra cash as an independent contractor and you work over 4 or 8 hours without 10-minute breaks or a 30-minute meal break, do you have to be paid for the breaks? And if you work more than 8 hours a day, do you get overtime? And again, this is as an independent contractor.
Yeah, all of these laws that I'm talking about right now apply to employees and not independent contractors. However, the definition of independent contractor is very strict in California. There are employers who want to classify people as independent contractors who aren't really independent contractors. For example, I had a case of some delivery truck drivers for a bread company. They worked 60 hours a week. This is their one and only customer. The company set their schedule, set their clients, told them what they'd be paid. That's not a true independent contractor. And if you're doing the work of the organization or the company that they're in the business of doing, you're not an independent contractor. California has made it very hard to classify people as independent contractors as a way of protecting these rights. Now, So anything to do with working 12 hours in a day or not getting breaks or meal periods, if you're a true independent contractor, you take them. You know, if you're a true independent contractor, you just decide you're going to charge them more. But that's why I'm saying most of the time you probably don't really have the power to do that. And it's really the person you're working for who has that control. And it's all about who really makes the key decisions and how much say so you have in the process. So if you're a true independent contractor, then you know, and you choose not to do that, then yeah, I see there's another question. What if you're working as an independent contractor for the state and they set up to pay? Yeah, if you're an independent contractor from the state, they're probably doing that right. I don't know specifically, you know, what your job is, but yeah, if you're like just a part-time intermittent kind of employee, or you know, say that you work for the city and you're teaching some dance classes, yeah, those they can classify as an independent contractor. But without knowing more about your job for the state, feel free to call me separately at Legal Aid of Marin, 415-492-0230. And perhaps I could give you more specific advice to your situation. Hope I answered that. Okay, going down the list, if we're sort of getting to where it says improperly calling employees independent contractors to avoid these wage rights. And in fact, again, that's why so many people were denied their unemployment benefits because they were improperly classified as independent contractors. So a lot of those EDD appeals specifically had to do first with, is this person properly being called an independent contractor? Same thing with some of the wage theft cases. A lot of times, the people who pick up the day laborers and they agree on a price for what the guy's going to do, you know, if he's an unlicensed contractor and he doesn't really have a business where he's regularly employing people and directing them, and he's in fact doing the work, that person is not an independent contractor. So again, people will use that term very loosely to avoid these rights. And so, okay. The other thing that happens in most of our wage complaints is and if you're a small employer, there are severe penalties for violating any of these things. And when you file a complaint with the Labor Commissioner's office, you can get hit with what's called waiting time penalties. The law says that when somebody quits, you must pay them all their wages due within 72 hours of them quitting. You can't just wait till the next pay period if it's more than 3 days. That will trigger the waiting time penalties. If you fire somebody, you have to give them their check with everything on it that day. So employers have to be advised that before you actually fire somebody, you need to get your ducks in a row to make sure that you're not only paying them all that you owe them for that particular week, but that you also have paid out all their unpaid vacation and other benefits and advise them about their COBRA rights to continue health insurance. So those things are really important. The longer an employer doesn't pay somebody the overtime that's owed, the meal period money that's owed, and they fight it with the Labor Commissioner, if the Labor Commissioner rules in our favor, then they have to pay the equivalent of a day's wage times a maximum of 30 days. And it's always the 30-day maximum by the time you get there. And again, that's really important because when we call employers to say, hey, not only do you owe these wages, we're giving you the opportunity to pay it now before we file the claim with the Labor Commissioner's office. Because if we file with the Labor Commissioner's office, many times, I have one case right now where the wages owed was $440 and the waiting time penalties are $5,600. So the penalties are high if the person delays in getting those wages paid to you. Okay, next slide. Next. Oops. Okay. Just some of the things about how to protect yourself. Right now, I know that the audience on tonight aren't probably day laborers, but we did create a calendar notebook where you should keep track of every day you work. For the people who work for a lot of different employers, you'd be surprised how many people don't know the name of the people that they worked for or any information, so it makes it very hard. But in terms of regular everyday work, you should record any day that you don't get to take your full 30-minute meal period. And you should also make sure you record any overtime, even if it's only an extra 10 minutes, 15 minutes, 20 minutes, you need to be paid that extra time and at time and a half. I really advise people to tell the employer about that for that payroll period. On some level, I understand that workers wait till the end of their employment to say that they didn't get all this stuff because they were afraid that if they raised it to their boss that, well, I really worked overtime and the boss doesn't want to pay it or yells at them, that they're not going to do anything about that because they're afraid of losing their job. So a lot of the times when people come to us, they may not even come to us knowing they had that right. They may be coming to us about a different issue. And that's where we start asking those other questions to find out, if they're possibly owed more money. But I would say it's always important, no matter what your job is to keep a record or a journal in your desk. That's not to say you're looking for trouble. And this kind of goes to, I was posed ahead of time some discrimination questions about, well, how would you document that and how would you go about it? And so what I would say is, if you're in a situation, we're going to get to harassment separately in a minute, or those kind of workplace things. The best thing you can do is to keep a written record of what's going on. If somebody made a really inappropriate remark to you, maybe you let it slide the first time or the second time, but if it starts becoming regular, you should really write these things down until you decide, what am I going to do about it? Well, we'll talk more about that when we get to that section. All right. Do keep track of your mileage, and definitely make copies of receipts. I find a lot of employees just give the original receipts. Hold on to those emails. Don't delete them, even if they really upset you. If you get a nasty email from your boss and there's a going back and forth, hold on to that stuff. Don't delete it. You'll never know when you might need that to back you up on something. So it's good to do that. Okay, next slide. All right. I did want to add some back to work protocol questions, because that's what we're getting asked about a lot these days. And one of the most common questions, and I think it has a surprising answer, is, can my employer require me to be vaccinated before my return to work? And the answer is yes, they can require it, and they can ask you if you've been vaccinated. Now, there are lots of privacy laws on your medical condition or those things, but Your employer can't talk to anybody else at work about it. They can't say, oh, everybody got vaccinated but Margaret, because Margaret doesn't want to get vaccinated. They can't do that. They have to respect your privacy. But an employer, for securing the health conditions of the office, can require that people be vaccinated. And there's really only 2 exceptions to this rule. And this is under both the recent EEOC guidance, which is the federal discrimination laws, as well as California's discrimination laws. If you have an actual religious practice that forbids it, for example, you're a Christian Scientist and they're against all vaccines and certain medical intervention or so on. If you belong to a recognized religion that has those practices. And secondly, if you have a health condition that makes it dangerous for you to get the shot, you can get an exception. But in those cases, you're going to have to get a note from your doctor. Fear of the vaccine is not a valid option for opting out. So that was an exact quote from an official of the DFEH. So I know people have strong individual feelings. You can have an office where 70% of the people have been vaccinated, and then what do you do with the 30% who chooses not to be vaccinated? Those are questions that employers and employees right now are negotiating the landscape to see how this is going to play out. There was a suggestion from President Biden today that employers do pay for the time off. If you have to get the vaccine, there's an appointment during the week, or you're sick from it the day after. California has put that actually into play right now. So if you do have to take off at 2 on a Tuesday to go get your vaccine, they should pay you for that time. And if you feel like me and many people I know, after the second shot, you might not be able to function well the next day, but the next day is fine. And they should compensate you for that. If you can't get if you do have the religious practice or a health condition, if you document that and your employer still tries to fire you for some reason, the remedy now is through the DFEH and which is California's Fair Employment and Housing Law, and the EEOC both let you file a complaint based on COVID-related discrimination. So that is an option. Also, if your employer doesn't pay you that 80 hours of sick leave, you would go to the Labor Commissioner's office, and they now have added on the forms for wage loss, not getting paid the sick hours you're owed. Another question is, if I get COVID and my employer refuses to pay me, how do I recover the sick wages? That's what I just mentioned. Going through the Labor Commissioner. And if you got COVID at work, you can apply for workers' compensation for those benefits if you get sick through it. However, because most people do recover from it, you'd only get a few weeks pay beyond when you would normally return to work. There is an established presumption that if you work in police, firefighting, and other frontline positions working with COVID patients, that you would qualify automatically. Okay. Next slide. Okay. Can my employer fire me because I got COVID or I had a family member? That should seem like an obvious no answer, which it is. It is illegal to fire somebody because they got COVID, but you would be surprised how many calls we've gotten from employees who were fired because they had COVID. And there's like a stigma out there for some reason that that if you have COVID or something, you're going to still pass it on to people. Employers are often requiring after the worker has had COVID for them to get another test that shows that they're negative. I think these issues, again, will diminish over time, especially if people have the vaccines. But that's where we're at with it right now. And this question of, does my employer have to pay for my time off? That is just like a really recent yes, and probably over the last few days. Next slide. Let's see, what benefits can I receive? Okay. I'm probably not going to go over these right now about if you're undocumented, because I don't think that's our audience tonight. But if I'm wrong about that, or if anybody wants to talk to me privately about that, again, they can call legal aid. But in general, they can get SDI, California paid sick days, supplemental paid sick leave, family medical leave, workers' compensation, but not unemployment insurance or the PUA benefits. Next. Okay. I guess I didn't have too many slides on discrimination. If there were questions about that, or if people have any other specific employment related questions, I would say if it's too personal, you probably don't want to ask about it on here, but if it's more a general question, I'm happy to answer any questions that you have.